Right, Constitution, week 4. So on Monday, we reviewed the double aspect doctrine and the cases related to it and paramountcy. We went over them in some detail, so this is probably an important part of the course. This week, we also talked about interjurisdictional immunity, the order of applying the constitutional doctrines, and we started talking about the judicature, and also hit a test on Wednesday. So to get started, interjurisdictional immunity is reading down a provincial or federal statute because it intrudes or trenches on the other jurisdiction, and this renders it inapplicable as opposed to inoperative if it were due to the doctrine of paramountcy, or invalid if it were due to the pith and substance, I suppose, intruding on the other jurisdiction. So this is generally used to limit the application of a legislation in certain circumstances. In other words, to render it immune to the circumstances before us. And fortunately, the dominant tide is to place less importance on interjurisdictional immunity, to narrow the scope of interjurisdictional immunity, and that is in favor of flexible federalism. So, for example, the double aspect doctrine, where for different purposes, the provincial or the federal government can make rules related to the same subject. But it's still useful. It's useful in protecting things, persons, and works or undertakings. For example, protecting federal corporations from legislation that affects the essence of the powers conferred by the federal government. So if they create a, they have the power to create a national corporation, and whatever is at the essence of that, the provincial government can't impact. Protecting Aboriginal peoples from provincial legislation that would affect certain aspects of their special status. I believe an example of this would be the Natural Resources Transfer Agreement, where there was a section in it which protected Indian reserves, protected their rights as per their relationship with the federal government. And it's also important to protect works and undertakings like nuclear power plants and interprovincial transportation. So the restricted approach to interjurisdictional immunity, this is the solution to it being applied all the time, because if it is applied all the time, we have asymmetrical results favoring the federal government, where power becomes gradually more and more centralized. So to determine if interjurisdictional immunity should apply, we decide what the core, or the vital, essential part of the undertaking, class, or matter is. So what is the core of, banking, for example? And then the statute must impair this core for the interjurisdictional immunity to be exercised. So if there's a ancillary intrusion, then interjurisdictional immunity wouldn't apply. So the example that we're provided with is Canadian Western Bank versus Alberta, and this was of course deciding whether Alberta's provincial legislation regulating insurance could be enforced on the banks because banking is within the federal jurisdiction, and it was decided that because selling insurance is not at the core of what a bank does, that they're not immune from the provincial legislation. So the decision in this case, providing peace of mind insurance is not absolutely indispensable to enable banks to carry out their undertakings. Thus, it's not part of the core of Section 91, and thus the Insurance Act is neither inapplicable nor inoperative. Orders of applying the constitutional doctrine. Step number 1, we look at the pith and substance and decide whether it's constitutional. So does this fall within the jurisdiction of the government that is making the legislation? Next, we test for paramountcy, and to do this, we ask if there is an intrusion, and if so, is the intrusion, to what degree does it intrude? So if there's no intrusion or remedial intrusion, and if there is a remedial intrusion, there's a valid regulatory framework, and the intrusion is functionally and rationally related to the regulatory framework, then the legislation passes the test. And then we go on to the interjurisdictional immunity test. If it doesn't pass the fifth and substance test, or it doesn't pass the doctrine of paramountcy test, then it will be invalid or inoperative. But if it passes both, we go on to interjurisdictional immunity, where we ask, again, what the core or vital part of the matter is and whether the statute impairs the core. And if it does, then it's read down to be inapplicable in the situation that is in front of us. And the reason they do this is the courts don't want to do this all the time. They don't want to determine what the core of a class in Section 9192 is all the time. It's an onerous exercise that they would prefer avoiding. It's also worth noting that Bastarache thought that interjurisdictional immunity should come before paramountcy in the order of the doctrine, and there's logic for that as well. If it's not paramount, or if the doctrine of paramountcy doesn't apply, the doctrine of interjurisdictional immunity could still apply. And if the doctrine of interjurisdictional immunity doesn't apply, then the doctrine of paramountcy could still apply. But anyway. So moving on to the judicature and the provinces. So the provincial powers, according to the Constitution, state that they have the exclusive legislative authority to establish courts of civil and criminal jurisdiction within the provinces, but they only have power to appoint judges to inferior courts. The federal government has the exclusive power to appoint judges to superior courts, even if those courts are established by the province. Now, which brings us to the difference between inferior and superior courts. Historically, inferior courts were of limited civil and criminal jurisdiction. Their jurisdiction had to be proven, whereas the superior courts' jurisdiction was assumed. The judges of these courts were called justices of the peace, and they were people of good repute but not legally trained. And they exercised power over property assessments, taxation, granting licenses, and road improvements. The superior courts, on the other hand, they existed in each of the United Colonies. They were courts of general jurisdiction, unless it was proved that another court or tribunal had that jurisdiction. And they were derived from the 3 royal courts of justice and attained all power of all 3. So the Queen's Bench, Common Pleas, and Chancery led to the formation of the colonial superior courts. Specifically with regards to the Queen's Bench, they were responsible for reviewing the decisions by the inferior courts by writ of mandamus or by writ of certiorari. And this has become what is known as judicial review. But the key point here is that the Superior Court of Justice has all the jurisdiction, power, and authority historically exercised by the courts of common law and equity in England and Ontario. So looking more closely at the Constitution, Part 7 is called the Judicature. Section 96 preserves in the Governor General the right to appoint judges to superior district and county courts. We don't have county courts anymore, so the superior courts. 97 and 98 ensures that the Governor General appoints people trained in common law to common law courts and people trained in civil law to courts in Quebec. There is a uniformity expressed in Section 97 that is not in effect, and it's likely never to be used. Section 99 and 100 ensure judicial independence by providing secure tenure and financial security. It's up to Parliament, though now I believe it's an independent committee, to fix their salaries and to pay their salaries and pensions. For provincial superior court, the judges are quite independent because they are appointed by and paid by the federal government. And for these reasons, Lord Atkin is quoted as saying that section 96, 99, and 100 are the three pillars in the Temple of Justice. Section 101 allows for the creation of courts for the better administration of Canada, and when they say Canada, they mean Parliament. So the courts that have been created are the Federal Court of Canada, the Federal Court of Appeal, and the Tax Court. I guess these are examples. These exercise the functions and powers of the superior courts, but they do not enjoy the constitutional significance of the provincial superior courts. They were created by statute as opposed to by the Constitution. And we see this with the territories as well, where they were given the legislative authority to establish courts of civil and criminal jurisdiction. But again, their power comes from federal legislation as opposed to the Constitution. So in the territories, the Governor General has the power to appoint superior court judges still. Section 101 also allowed for the creation of the Supreme Court of Canada, which is inherent in any federal nation. It is the General Court of Appeal, and they hear or they receive applications for leave to appeal, and that's generally how most appeals get to the Supreme Court of Canada. Though I believe some can get there automatically if there is a certain amount of dissent in the Federal Court of Appeal or the provincial Supreme Court. I'm not sure. Uniformity in the Constitution. The Supreme Court of Canada and the Judicature section of the Constitution are seen as promoting uniformity in how federal laws are applied and interpreted. However, regarding civil law, because we have two traditions in Canada, the civil and common law system, that uniformity is not so much desired. With regards to provincial power, the provincial superior courts can interpret and apply both federal and provincial law. But their interpretations are subject to the exclusive jurisdiction of other courts that relate to the matter that they're deciding. And the key point here is that to end this section, superior courts may not be known by this name. They're identifiable by their functions and their powers. So their powers are derived from the historic courts of the Royal Courts of Justice. And they have the power to interpret and apply both federal and provincial law, and also the power of judicial review, possibly other powers. So protecting the provincial Supreme Court or Superior Court, following Confederation, a judicial committee affirmed the provincial authority to appoint persons to exercise limited judicial powers. So this is the royal prerogative to appoint judges, and it was decided in Liquidators of Maritime Bank versus New Brunswick in 1892, where they found that the Lieutenant Governor is equivalent to the Governor General as a representative of the Queen. And this decision applied with equal force to the ability of the provinces to appoint judges as to the federal government to appoint judges. Expanding the power of inferior courts. In 1938, Chief Justice Duff said that he's unable to accept the view that the jurisdiction of inferior courts is to remain fixed. So this was a response to a question regarding the validity of an increase in the jurisdiction of provincial inferior courts in relation to protection orders for the benefit of deserted wives and children and orders of adoption. So there was a certain amount of pressure to allow the inferior courts to make broader decisions, and Chief Justice Duff agreed. And this led to more specialized tribunals, such as the Labor Relations Board of Saskatchewan. But these specialized tribunals need to have, I suppose, a certain limitation on their powers. In 1948, in the case of John East Iron Works, the Labor Relations Board ordered the employer to reinstate 6 employees and pay their lost wages. And when this was brought to court, Lord Simmons created kind of a 2-step approach for determining the legitimacy of the specialized tribunal. And so his questions were whether the appealant board exercises judicial power, and whether in the exercise it is a tribunal analogous to a superior district or county court. And I don't exactly understand this test very well. I'm hoping it will come out in the future. So Lord Simmons didn't think it was necessary he didn't think it was necessary to restrict their powers in this instance. He concluded that the administrative body heard a complaint from a trade union seeking to enforce a collective agreement, as opposed to an individual employee seeking a remedy from an individual employer, and perhaps that might come back to were they exercising judicial power. I'm not too sure. So looking ahead to, or I guess around this time, post-World War II, policymakers decided that a strict approach to Section 96 would undermine the efficiencies gained by specialized tribunals, and so there was a large increase in administrative tribunals. And what these did was remove many of the disputes from the generalist court system and put it into a setting where they had an expedited process and expertise in that in those areas. So moving ahead to 1975, the Tomko versus Nova Scotia Labor Relations Board. This case confirmed the power of specialized agency to issue a cease and desist order in the context of a labor dispute. Here's a quote from that case. "It is not the detached jurisdiction or power alone that is to be considered, but rather its setting in the institutional arrangements in which it appears and is exercisable." So I think that this is the test for whether the jurisdiction, the validity of the jurisdiction is allowable or not. And here it seems to be broadening to, we need to look at the greater context, we need to look at the institutional arrangements and not just what powers they are exercising. Which brings us to the Residential Tenancies Act, one of the main points of this chapter, 1979. In 1978, the government recommended the creation of a single commission to deal with residential tenancies, and they would provide advice and administrative services. So it would consolidate the advisory function of the Tenant Advisory Bureau and the administrative functions of the Residential Premises Rent Review Board and the adjudicative functions of the Superior District and County Courts, thus diverting a lot of matters away from the general court system. Now, the questions that they had to ask in relation to the Residential Tenancies Act was, is it within the legislative authority of the Legislative Assembly of Ontario to empower the Residential Tenancy Commission to make an order evicting the tenant? Also, they wanted to know if it was in their power to give power to the Commission to make orders requiring landlords and tenants to comply with obligations imposed under the Residential Tenancies Act. So basically, can they have the jurisdiction? And in the discussion of that case, presumably we're going to get a test to decide how we determine the jurisdiction of advisory or special tribunals. The decision was no to both, but they adopted a now familiar 3-step approach to the application of Section 96, which we will cover in the future. Let's move forward, Constitution.